Hello everyone, good evening. Hello, can you hear me? Good evening. Please someone confirm that you can hear me.
Yeah, I can hear you, sir.
All right, thank you. I've added your care. Thank you so much for joining me for the session. Welcome everyone to the Gypsy Mentorship and Internship Program. That is, we are currently in week two of our intellectual property course, and in today's class, we'll be discussing intellectual property for creatives and innovators slash inventors. So thank you everyone for joining in. My name is Dennis Williams, and I will be your moderator for today. So please, I would like to kindly employ us to reach out to our co-mentees. That's for the mentees that are already on the call. You can send out the links to the class and reminders to your subgroups that class has started so that we can have more people joining for the session. Remind your friends that we are going to be heading into the business of the day soon. So not to waste any time, like I said, our topic for today is IP for creatives and inventors. So we'll be going ahead like we did in the last class. We'll be introducing some of the mentors that we're expecting into the class. We are hopeful that because of their busy schedule, sometimes we do not get to have all our mentors join in on the call. But for those who will be joining in for the call, I am sure that they will do due justice to the topic of the day. So not to waste any further time, we would like to introduce our mentors. We already have one of our mentors on the call. So, you will get to meet them once I continue with the introduction. So, um, first and foremost, we'll be introducing Mr. Sand Mbakali. Mr. Sand was present in the last session, so I may not necessarily be reading his profile, saying that we've already met him, but he was a very key part to the last session that we had on IP for business, and I trust when and if and when he does join into the class, we'll be able to get to hear from him, share some of his thoughts and perspective on IP for creatives. So we want to say a big shout out to Mr. Sam for everything that he does for us on the Gypsy Mentorship and Internship Program. Next, for today's class, we have Mrs. or Miss, sorry, Ma, you can correct me when you come on board. That is Rina Apata. She is already on the call. Thank you so much, Ma, for joining. Rina Oluwatosin Apata, preferably called WOA, sorry, is an intellectual property and development policy advocate, consultant, and enthusiast with more than 5 years experience. Her interest in IP started during her undergraduate program at Obafemi Awolowo University, after which she founded the first IP Students Club, that is the IPLCOE. She has since consulted for a number of startups, worked as a project manager with tech startups, and the Africa First Consultants for International Trademark Association in 2022. She is currently pursuing her master's degree in intellectual property and development policy at the Korea Development Institute of Policy and Management, where she is also serving as a student representative where she is also serving as a student representative for the 2024 IP cohort. She currently runs her own IP consultancy outfit, where she is focused on growing social impact startup leveraging on intellectual property. In her spare time, she loves watching YouTube videos, playing board games, and writing. You can connect with her on LinkedIn, Rina Oluwatosin Apata, or via her email, Oluwatosin Rina Apata at gmail.com. Thank you so much, Mark, for joining in on the call. We are happy to have you in this session today. Next, we have Mr. Folarin Aluko. In the last class, he wasn't able to join us because of the schedule. We hope that we do get to see him in the session today. Like I said, for mentors who we have introduced before, we would not be running through their profile again, just to save up on time. So thank you so much, Mr. Folarin, for everything that you have been doing for us. Like Mr. San Umba Ali, Mr. Folarin has also been a very, very key contributor and part to this program, especially under the intellectual property course. He has spent quite a number of years with us sharing his knowledge and insights into intellectual property. So if he does join us, we would gladly and happily receive him. Next, we have Mrs. Regina Chene. Yes, this is Regina. Also, we read her profile in the last session. Still yet not with us. We hope that she does eventually join us at some point in the class. Right, but Ms. Regina, we thank you for everything that you do for us, and we want to say a big shout out to you. Okay, I think that is that. This is another flyer. Yeah, so we are done with our mentors flyer for this particular session. And so far, we have one of our mentors already on the call. That is Mrs. Wina, or WOA, as she prefers to be called. So what we are going to be doing is after the presentation from our mentor, that's Miss Wina, right? We are going to be taking mentee's presentation. So please, mentees, I would like for us to start getting ready from now so that once we call you, we don't have those back and forth that we do have where we are trying to get you on board. So please, if there's a way to sort out the issues around who is going to present, right, let's try to do that right now. Yeah, so moving forward, we would like to give the floor to Miss Rina to give us. Sorry, my background is kind of dark. Well, having some light issues over here. So we'd like to give the floor to Miss Rina to give us discuss into today's topic, that is IP for creatives and inventors. You're welcome. You have 30 to 35 minutes for your discourse. You're welcome.
Hi, thank you. Thank you so much for the introduction. And thank you. I see that I mean, miss, not a missus. Okay, so yeah. Good evening to everyone. It's morning my time, but good morning. Just give me about 2 minutes. I'll be right back. Just 2 seconds. I just need to ensure that everything is working on my end. Please hold on.
All right, ma'am.
Hi, everybody. I hope you can see me and I hope you can hear me. I'm not sure. Am I the one sharing my
Yes.
screen, or you are sharing my screen for me, or you're sharing my presentation?
Uh, I would prefer if you're able to share your presentation, even though I can do
Okay.
that.
Okay, that's okay. Hi everyone. Said that earlier. My name is Winner, but everybody, or I prefer people calling me WA. Think that is much better. And I will be talking to everyone today about IP for creatives. If you have any question, please feel free to interrupt me anytime. Um, okay, so yes. Yes, so you can see my screen. So I'm talking about IP for creatives today. And I'm coming from perspective of not just your regular creatives, not just your music directors, your artists. Now, between 2020, I think it was in 2020 when COVID happened, we saw a new wave of creativity because people were at home and then everybody was bored. What can we do? When will it stop? When can we come out? Creativity was unleashed, and we saw a new mix of creators. We call them content creators. Okay. Um, Content digital creators, influencers, and stuff like that. So today we'll be talking about that's what I will be talking about. And the objective of this lesson is to understand how IP protects digital creators, influencers, and content producers. So, like I said, now we have a rise with in the creator economy. Millions of creators now produce content on digital platforms like YouTube, TikTok, Instagram, podcasts, you name it, right? And now content has become an economic asset, right? Now it's even a career path for people. I'm sure that if I were to take a poll on this call, I would at least have maybe 10 or 5 people that would say they're content creators, they're influencers, or they're trying to be, or they have interest in it. And creators now operate like what's it called? Media companies. Now, some key facts will be that Nigerian digital content creators, they generate about 200 million annually from platforms, brand deals, and advertisements. Same brands said that they spent about 80 million on influencer marketing in 2022. And by 2025, that was even last year, it was supposed to go to $150 million, not in naira, in dollars. The digital advertising and influencer platform marketing in Nigeria is about $300 million. So it's a lot of money, right? It's it's if care is not taken, it might even take over from what's it called digital content, music. I mean, we'll still have music, but these are the new crop of creatives that we'll be talking about, at least for your generation. So, sorry. Okay, so who are content creators? They are the influencers, social media personalities, YouTubers, video creator, podcasters, you name it, streamers, gamers, online educators, course creators. Those are people they call content creators. And why does IP matter for these people? Because more often than not, they still produce digital original content. IP helps them monetize their content. It helps them prevent unauthorized copying. It supports brand building, enables licensing and partnerships, sponsorships, you know it. That's why IP is also relevant for these people. And what IP would we say apply to the people? The name, what's it called? I think it's still the traditional ones that we have copyright, trademarks, maybe not patent, but we have design rights, we have trade secrets, and we have personality image rights that protects their identity. So the traditional IP rights that you know, copyright, trademarks, it still applies to what's it called, content creators, right? And now in the digital content world, right? How does copyright apply in digital content world? First would be it protect original creative works, either in music, either in slogans, either in video, anything that they come up with, it still protects it. It arises automatically upon creation in most countries. And creators keep records of their authorship. And it's also important for enforcing rights against plagiarism and reposting. Trademarks, on the other hand, how is relevant in today's content world is creator names have now become valuable brands where you say something like, oh, I work with, do I have a favorite? Someone should give me a name. What's it called? Maybe someone's favorite content creator. Can anyone help me?
They are Shaggy.
Yes. If you say something like, oh, you work with Brother Shaggy, it opens doors. Or you've worked on a project with Brother Shaggy, it opens doors. And it has become a valuable brand, right? A global name. Logos, catchphrases, and show titles can be trademarked, right? It also protects identity in commercial markets. It prevents impersonation or brand confusion. I don't think Brashag is actually his real name. I think it's just his, what's it called? Social media name. I'm not sure it's Brashag is his real
Yes.
name. I don't know what his real name is. Right. But for most of these people, they come up with, say, names that are catchy, that appeal to their people, right? Like someone like Kiki, or yeah, I think I'm not sure that's her real name, but that's what she calls herself, right? So everybody knows Kiki now, right? So these names that they come up with can be trademarked or should be trademarked if they know what they're doing, right? Now, the risk for common risks that creators is that they use first now because of how diluted social media is, we all use music, copyrighted music without permission. And I think it's also because they're under the assumption that platforms have licenses to, right? Or reposting people's content without credit or license. That is very, it's very tricky. You can't just repost anymore, right? Especially if it's like an educational content. If you're not going to tag the person that made the content, you can't, or the creators get sued for unauthorized reposting. Meme culture, for example, an unclear ownership. We don't even know who owns what. At the end of this lecture, I'll give you a case study that was it called? I remembered when I was making this presentation. Using images from the internet without permission. Those are some of the risks that the digital world now pose when it comes to IP for creators. How can they monetize their IP? Is again through advertisement, sponsorship deals. They can license content to media companies. They can sell digital products and merchandise, subscription communities, brand collaborations, content syndication. The whole works. That's monetization avenue for content creators. Now, some of their best practice will be, and like I said, most of them actually do. I know for a platform like UGC, they only deal with influencers or content creators that come up with original content. That's why it's always important to them to always create their own content. Registering trademarks for brand names, understanding platform copyright policies, using licensed music and images, keeping contracts for collaborations. Those are some of the best practices that a content creator should adopt to ensure that they don't have IP or they don't get dragged into IP disputes. Now, this is actually I'll say this is probably the summary of this entire production is how does it affect you? How does it concern you? Because I won't say IP is an emerging area of law anymore. I would say at least now we have a good number of people that know about intellectual property. I mean, at the time that I started in IP, or say my predecessors, your other mentors on this call, IP was not so prominent, but now it is. And we've been able to work with, say, the music people, the artists, the directors. They already have their lawyers, but how can you position yourself? Thankfully, some people are still in school. Look out for those people that maybe that's some of the choices that some of us should have done. I don't know if you know this guy, Fireboy. He went to AU and fortunately it wasn't my set. So we did EGL, is it EGL? Yeah, EGL 101 together and FA 101 together. Maybe if I had known, I would have positioned myself as his friend. But now, who are the similarly content people around you in your school? It can be free legal advice, right? Of course, do your research, but free legal advice. That's how you position yourself with these people so that at the time when they make it right. They know that, oh, this person is experienced or knows what she or do is saying or doing when it comes to IP. My IP will be protected or will be safe with this person, right? Career opportunity, emerging career opportunities for IP people, for IP specialists in the creator economy will be one. We still need IP lawyers. We need IP managers in creative companies. We need digital rights and licensing specialists. These are really specialized areas that you can look into. We need IP policy and development specialists. We need creator economy advisor. We need IP analysts or researchers. What is the trend saying right now? How can this person position themselves? Right, these are emerging career opportunities. I would encourage your generation or you people to look into. Right, it's not. Thankfully, now you know about IP. There are resources. There are people you can talk to. But now I would want you to think long term, right? I don't encourage, when I talk to people, I don't encourage people to take conventional IP career paths, right? Think outside the box. IP is a blue economy, which means that it will always, 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 always metamorphose itself. And there will always be career opportunities springing up for people. And how can you position yourself? That's the crux of my message of my slide this evening. Now, sorry, please, I need to get my phone. There is this soundtrack I heard. It's just like a little quiz that I want to do. So you, sorry, just give me about 2 seconds. Let me get to my phone. Okay, sorry. Can you please confirm that you can hear me?
Yes, we can hear
And
you, ma.
okay, thank you very much. Um, and please feel free, anybody should feel free to unmute their mic if you can get it. So I'm going to play it, this sound, and tell me, yeah, tell me where you recognize it from.
Listen, please. I'm a streamer. I'm big. I know. But please, let's do something. I've suffered because of you.
That's Eniolua.
What?
Eniolua on Instagram.
It's
No?
Stella.
Thank you. Who said it's Stella?
It's Sophie from Gypsy.
Who said it's Stella? Who answered me that it's Stella? Who said it was Stella?
It's Sophie from Gypsy. Sorry, I'm not a mentee. I responded.
Oh, it's okay. You're not a mentee?
Yes, I work with Gypsy.
No, please. I'm asking for what's God. I'm asking what's God asking about mentees.
Hello,
But
good
thank
evening.
you. Yes, please go
Good
ahead.
evening.
Good
Yeah,
evening.
it's actually Pella. That was when the one of the biggest streamer in the world, Speed, came to Nigeria. I then was trying to connect to him, but Speed didn't really pay attention to him while I was in his car. So Pella was chasing him and then trying to get him to talk to him, but then he didn't talk to him.
Okay, thank you very much. Abhi. Please try to get my contacts from them. I mean, I think they have it from someone here and send me a mail. So, do you know how many posts people was it called made, or how many posts were made to this soundtrack? Who can guess?
Sorry, are you talking about the exact numbers?
Just give me a rough estimate of how many posts you think was made.
Actually, I don't know about the exact number or estimate, but I don't even think there were a lot of posts. In fact, there were actually a lot of people ridiculing, even celebrities ridiculing Pella for how he reacted. That they were trying to like tell him that he's also big in Nigeria in his own right, that he shouldn't have ridiculed himself in that manner because he should have just maintained and stayed on his lane, and then people will have linked him up to speed without him stressing himself too much.
Mm, thank you. So, there were more than 2 million posts for that soundtrack. What do you think you could have done? See, I'm not even concerned about how he made a fool about himself or with himself. That's not my problem. But think of it as a business person, as an IP person here, right? And what's it called? You saw that it went viral. What would you? So imagine if it was your client and he came to you. That so the foolery made himself or he made of himself as because even prior to now, prior to that video, I'm not his target, right? I don't know anything about the guy. But now, because of that video, I know him, or I know of him. I never knew anything, right? Or this other guy, what's his name? Is he a bouncer that said you are fit for 21 years or something like that? Prior to that,
Egungun of
you see,
Nigeria.
I had never heard of that guy before in my entire life. Never. But because of the, again, what's it called, the stupid comment, people know, at least people like me know him. So imagine if they were your client, what would you advise them to do? As an IP person,
Short
as an IP
or
specialist here.
copyright.
Say that again.
Copyright. Like that's just to copyright it.
After that, I'm asking you, don't think as a lawyer. Okay, you're thinking about
Oh,
registration. I'm saying think as a
okay.
business person. That's what these people need. How can they convert this into money? Because see, when you go on TikTok and you search for that audio, it was credited to someone else.
Okay.
And
Okay.
that's
Okay.
that's one
No.
of the risks that these people face, is that some of the taglines, some of the things, or create, what's it called, some of their it moments, some of those moments that actually go viral, it's never credited to them. But the original video came from him. Someone just extracted that part and put on TikTok, and then they named that person the creator, but he wasn't the creator. The creator is Pella himself. And
Yes.
that's one of the risk of what's it called social media, is that it's about who got it on the platform, not who actually made it. So as the specialist or as the business person, my advice would be, first, you have to report it. It's yours. What's it called? Actually, you are the one that actually made the video. It was a moment where you made a fool of yourself. Yes, but it became a hit moment where millions of people now, if like millions of people that are not even Nigerians, now know the guy. And that's what I'm talking about when you say think outside the box, right? How would how can you monetize their content for them? How can you monetize their platform, their viral moment, their viral slogans? Those, I don't know. It's like, I mean, unlike music where it's songs, right? You can keep playing that, keep playing that, keep playing, and over time it will generate what's it called, income. Content is not like that. It's just one moment. After a while, people forget it. I mean, who else can remember the viral moments that what's it called, from content creators from last year? I can't. But in that moment, how can you monetize it for them? If 2 million people were paying, even if it's $1, to use that video or to use that audio, do you know how much you would have made? A lot of money from just one viral moment. Anyways, I don't want to take anybody's time. That is my lecture for today. Thank you very much for listening, and I really hope you had a great time. Thank you.
Thank you so much, Ma, for taking our time to teach us. I appreciate. I learned a lot from your lectures, and I look forward to thinking outside the box, just as you have encouraged. I also took notes, and I hope to go through my notes. I also hope that the slides will be shared too, because I would like to say that a lot of value will actually share through your notes. Thank you so much.
Sorry, yes, before I go, I'm not, what's it called? Thank you very much for your kind words, which reminds me, actually. So, I'm working on a project. I'll say it's been a long time coming, and it's also in relation to what I discussed on what's called career pathways for people if I had the guidance that is available now to the younger generation, maybe some mistakes that I made or have made in my career, I wouldn't. So I am publishing on the 24th of next month. That's what I did. The first book on careers for IP people. So I'm writing stories about IP people that I've met that have done unconventional things in their career paths. People that probably studied marketing, that did science, how they transitioned into IP, what are the career options in IP, what people can do. So watch out for that. It's going to be out on the 23rd, 24th of next month. And I really hope that everybody gets a copy of it. Read it. If you really want a career in IP, it is very possible. If you want a career in IP outside Nigeria, it is it is extremely possible. It's not just, we don't just need IP lawyers anymore. If IP in Africa or in Nigeria will thrive, we need people in other parts of IP. We need patent examiners, we need auditors, we need IP managers, and like, so look out for it, and well, I hope you get a copy for yourself. Thank you very much.
All right, thank you so much, Ma, for your presentation and also the discourse that you made in class. We are very, very happy that we are able to learn from you through your shared experience and the practical nature from where you brought how IP can become beneficial to persons who, to lawyers and to even people who are just generally enthusiasts in that space. So thank you so much, Ma. We sincerely do appreciate. We have Mr. Folarin in class. Thank you so much, Mr. Folarin, for joining. We are happy to have you in the session today. So, sir, we also want to just hear from you in the next few minutes. Share your own thoughts on what you have for us concerning IP for creatives and inventors. You're welcome, sir.
Hi, good evening. I'm so sorry. Um, I'm just joining you, but it's always a pleasure to be here. I'm sure you can hear. I was prepped and ready to go, and then the call came in, so I had to answer to a very urgent call. But I caught the latter part of the presentation, and I should commend. I would always commend the presenters for the industry that goes into the presentations, particularly when you look at the attempts to make the presentations as practical and as current as as possible. So well done. If I were to speak generally to, I think I did a little review of some of the two presentations, and I would say that one of the things I noticed for purposes of correction was I think I noticed some references to laws. I think the law review could do with some work, but I like how both presentations address different aspects of the creative industry. Although when you talk about creative generally, that phrase captures, it's such a broad phrase, such a broad word rather, that it captures a very large group of amorphous entities. They're entities that may not have anything in common with each other. The word creative refers to filmmakers, songwriters, inventors, poets, and any, very large category of people. So I would say well done in terms of, capturing these different categories in your presentations. If I had to speak, so that's advice I think for both presentations. That's based on what I read, not the presentation I listened to. I think the law review could do with some work. I would encourage you to please look at pay a little more attention to the law review, because intellectual property rights are actually rights provided for by law. So the distinction between intellectual property and intellectual property rights are the existence of legal frameworks, that now ensure that the property can be protected and enforced, in the event of a breach, or in the event, or when, in the event that somebody needs to activate it. From my practice experience, I asked myself a few years ago what creating would be like without an intellectual property framework. And I think it's hard to imagine a world. It's actually hard to imagine a world without an intellectual property framework. And I think what that does for me is that it emphasizes the importance of intellectual property and intellectual property rights, for creatives. But I think the question that we have, or the question of our time, the question for today is whether the intellectual property frameworks that have been developed thus far are sufficient to cater to the new forms of expression, the new platforms that are being developed, and the new ways that people are interacting with and enjoying media. And a good example is this mix, or this mashup between "Bees in a Trap" by Nicki Minaj, and this other song. Somebody did a mashup, two different songs, that came together as a whole new song, and it gave life to both songs. I watched one of the videos. I forget the name of the band now, but I watched their video. I'd watched their videos some years ago, and they had about 10 million views. But after the mashup came out, and the mashup had all manner of people doing, it was part of a challenge. So you had members of the US Congress, you had celebrities participating in that challenge. And when I looked at the song again on YouTube, I saw that it had gotten almost a billion views, about 800 and something million views. But then the question is, one person on an app on TikTok mashed together two different songs that don't belong to that person to create a third song, and you would ask, in copyright terms, does this amount to transformative use? And if it doesn't, do our copyright laws, who should be compensated and to what end? Should the person who made the mix be compensated, or should it be the two original owners of the copyright in those works? So there's a real question about the extent to which, and then should such mashups be allowed? And I would say that clearly there's a market for it, because the market received it very well. So the question really for our time is whether the intellectual property frameworks that exist today are sufficient to address the type of media or new media of our generation, if you may. I heard someone talking about Pella, the streamer. Who owns the copyright in a stream? Is that the same thing, or what rules govern copyright in streams? Can I take a stream from Twitch and upload it, or what's it called? Can I stream it, or take a stream from Twitch and put it on YouTube, or take somebody's stream from Twitch and put it on my YouTube channel? what are the rules that will govern. I have noticed the growth of debate channels. They have debate platforms on TikTok, and then somebody is debating on TikTok, but is live streaming the debate on YouTube, from their own perspective. And these are all different forms of usage of, creative work. So the question is whether our laws because laws always play catch up with innovation. And that is unfortunately the nature of things. So, I think those are the questions that will agitate our generation. But once again, thank you very much. You asked for 1 or 2 words. I have given 3 or 4. And I should say, well done to the mentors. It's always a pleasure to be here. Thank you so much for having me. I'll just take a back seat and wait for further instructions. Thank you.
All right, thank you so much, sir. We are grateful for your shared thoughts in the class. So what we'll be doing now is we're not actually taking presentation yet. The earlier first speaker who spoke was one of the mentors that was what I was supposed to speak in the session. So we have already had 2 mentors speak, and then now we'll be heading over to presentations, pending on when other mentors will be able to join in. And if they will not be able to join in, we trust that both Mr. Folawin and Ms. Rina can help us run through what is left of the class, including our question and answer segments. So over to the mentees, please, the coupon presenter, if you are with us, please kindly go ahead. Hello, can you hear me?
Good evening. Yes, I can hear you. I'm trying to see if I can share my screen.
Yes, good. All right. So if you encounter any difficulties with that, just let me know so that I can see if I can help you with that.
Okay, sir. Okay. Enter my screen.
So while the presenter is making presentation, please let the presenter proceed.
Hello. Can everyone see my screen now?
Yes, we can see your screen.
Okay. So today we'll be talking about intellectual property for creatives and inventors. So as a form of introduction, we all know that Nigerian has a very huge creative space. We have content creators, we have musicians, we have filmmakers, we have fashion designers. We have a lot of these creators that most of them don't even know how to protect their rights or how to enforce their rights in a situation whereby their creation or innovation has been infringed upon by a third party. So the purpose of this class is to discuss ways by which these creators can protect themselves, or when their rights has been infringed upon, how they can institute actions, or the steps, or let me say the type of IP to institute in the court of law based on their creation. So first of all, we're going to start with literary works. Literary works are works that are written, printed, speeches or addresses, anything that is basically in a written form are what we call literary works. These are works that once they are created, or like books, once they are created by these authors, it's it serves as an identity to them because everybody sees their name on it or sees their brand identity or whatnot that signifies that the work is for them. So most of these authors, they just write these things or just put them in to the public without knowing their rights and how they can protect him. So literary works, which includes everything from novels to short stories, essays, and poems, fall under the umbrella of copyright. Authors automatically gain exclusive rights to their works, including the right to reproduce, distribute, perform, and display them in public, or also adapt them. This is saying that once these things have been done, they have the exclusive rights to authorize others how to use it, whether to reproduce it, how to distribute it. And a real life example of this is I want to give an example of adaptation of a novel to a movie. So we all know The Secret Lives of Baba Shegi's Wives. The author is Lola Shoreyin. So Moabudu got the rights to adapt the novel into a movie. The movie is not yet out, it's going to come out in December. So this is one of the rights an author has. Moabudu can't just go ahead and create that movie without asking for the consent of Lola Shodeyin because that would be an infringement on her rights, and that's going to be giving Lola Shodeyin the power to enforce, to institute an action in the court of law and to claim damages from Moabudu if she hadn't like reached out to her for the adaptation of her work, of her novel into a movie. Copyright lies for the author's lifetime plus 70 years after the death, offering long-term protection and control over the use of their intellectual creations. For joint literary works, protection lasts for 70 years after the death of the last surviving author. So once you create a literary work, you're already protected from copyright. And even after you die, you're still going to be protected up until 70 years after you've actually died. So in a case whereby two authors wrote a book or wrote any literary work, up until the death of the second author, they are still going to be protected. Even if the person, one of the authors dies early, it will still extend to the time the second author actually dies. So that's to show that it is actually a very big and important right for create for creatives to actually know so that when their works are actually being used in manners that doesn't align to what they want it to be used, they can actually institute an action and be protected. IP rights can be enforced if someone uses another content without permission. The owner of the content has legal grounds to demand compensation or stop the authorized use through injunction. Like I said earlier, if Moabudu hadn't asked for the rights from Lola Sholeyin to adapt her novel into a movie, then Lola Sholeyin can actually institute an action in the court of law to stop Moabudu from the movie or actually gaining any monetary benefits from the movie because it is not her original work and she's adapting someone else's work into a movie. So what literally that's basically what protects literary works. Copyright is the main thing that protects it, and it is very important for creatives to know that once they have created their work, these are the steps to be taken, and these are the things that can be protected, or these are ways that you can create institute actions in the court of law to claim damages so that another person won't benefit from the work they didn't create. Secondly, we'll be talking about visual arts. Intellectual property for visual arts protects original creations like paintings, sculptures, and digital arts, granting artists exclusive rights to control, reproduce, display, and profit from their work. So, an artist has the exclusive right to dispose his artwork any manner he likes and he deems fit, as long as it is an original creation, meaning that it must have been the person that created the artwork to get these benefits, and not that he copied someone else's work or adapted another person's work. Also, for visual works, copyright is also the intellectual property rights that can be protected if someone else uses the artwork of another creator. This is to show that once an artwork is also created, the author or the visual artist actually has the right to be protected under copyright, and also prevents other people from using his work without or is him authorizing them to use it, and putting a dent in his image, or making monetizing the work of someone else without them giving the rights to do so. Key aspects of virtual arts include copyright protection, grant artists control over how their work is used. Like I said earlier, the artist can give the authority on how his arts can be used. Physical versus IP ownership. So this is trying to say that as an artist, if you sell your art to someone else, it doesn't mean that you've transferred your IP rights to the person. I'll take that again. If you have sold your artwork to someone else, it doesn't mean that you've transferred the copyrights or the intellectual property rights to the person. The IP right is still going to be with you, because you can actually sell multiple copies of that particular work to different people. So selling it to another person doesn't mean that you actually transferred your rights to the person. Moral rights, that is attribution, that's when like you are going to be credited for creating the work. The first one is economic rights, selling it for profit. That's the economic rights. Well, moral rights is actually being known as the person that created the work. Licensing and contracts. Artists can earn income by licensing their work, by giving other people, like putting your prints or your design or your artwork on shirts or other like merchandise to show that it is your work. So you can actually license that for that. You can just sign a contract with a third party, and then they'll give you a percentage from the merchandise, and then that's like an importance of contracts in intellectual property law. Digital technology makes copyright easier. So tools like NFTs and being explored to track and sell digital art. NFTs are non-fungible tokens. These are like digital tokens that you can actually you NFTs are like you upload like an image and then you sell it. So once the image is sold, another person cannot re-upload the image to sell again. So like it will track that this thing has been uploaded and it has been sold already. Artists should document their work, use copyright notices, and understand contracts to protect and maximize the value of their creation. Exactly. Like I said earlier, if you are going into a contract with a third party and they don't want to use your artwork for merch or any of their souvenirs, like you have to sign a contract so that it won't go south and they won't claim your work if the written agreement is not documented. Or if the agreement is not documented. If it is written, that means it's documented. Anyway. Okay, for dance. Intellectual property for dance primarily protects original choreography through copyright, requiring the work to be fixed in a tangible form. So, for example, if you like a dance group now, they can like create a new dance and then record it. The tangible form means that it has to be there has to be an evidence of documentation. And it must be something very creative, unique, arranged movements, not common steps, social dances, and individual gestures. It has to be coordinated and creative, not something that we see every day and anybody can actually do. It must like have a sign of being unique, that it is different from what you've seen before for it to be protected. Key protection includes copyright, protects the expression of the dance. That is, once recorded, it protects it that, okay, this belongs to this person and any other person who uses it as infringed on the on the dance group's copyright. Trademark, like the dance group's name, their brand identity. Like, for example, Kafi Dance is one of like the biggest dancers in Nigeria. Once you see a brand or a brand identity before a video starts, you know that okay, yes, it's Kafi that is about to start dancing. So it's like a form of identity to make people know that okay, this is my brand and this is what belongs to me. So that when another person copies it, every other person will know that no, this doesn't belong to you, this belongs to Kafi. Related rights covers costumes, like music you dance to and performances. So yeah, everything that you did to make the dance come to pass, like what the clothes you wear, the music you're dancing to, like the routine of
Sorry,
the performance.
excuse me.
Sorry?
Yes, Habib, sorry to interject. Yes, can you kind of try to speed up your presentation, right, so that we can take the next group's presentation also and get
Oh,
feedback and do all that in time? Thank you.
okay. Sorry about that. I'll try to be as fast as possible. Key aspects of protecting dance IP is fixation requirements. Like I said earlier, you like it must be recorded so that there will be an evidence for documentation. Originality, you must have been the person that created it. Nobody has created it before. Ownership, the creator of the choreographer is typically initial owner of the copyright. Like is the person, if it was Kafi, for example, that created the dance, then she's going to be the owner of the copyright of the dance. So she'll be the one to institute an action if someone else tries to steal her dance moves without consent. Limitation, individual dance steps and common movements are generally not eligible. Exactly, like I said earlier, just normal just normal routine dance is not eligible. It has to be coordinated, it has to be unique, it has to be creative before it can be eligible to be copyrighted. Film, intellectual property in films protects creative, like it, intellectual property in film protects every aspect of the film from the script, from the performance to the just everything, the music used. And I'd like to give an example for this. There's this movie, Bimba Ademoye, she's a Nollywood actor, created in December of last year, Love in Every Word. So she actually asked for permission to use a particular song by Ugochi in the movie, which Ugochi granted. So there was actually one individual, Emmanuel Davis, that actually uploaded that song independently. The movie was uploaded on YouTube. So the other guy, so Emmanuel Davis, uploaded the song on YouTube as well. And then the monetization of the movie was directed to him because YouTube thought he was the original owner of the movie. And then the movie garnered up to like 20 million views in like 5 days, and all the monetization from the movie was diverted to him. And then Bimbo Ademoye went on Instagram to call him out. Though they later resolved it, but that's just an example of like copywriting movies where another person is trying to steal another person's work because they feel like they can go scot through with it. So chain of title, everything, the title, the actors, the crew, everything is protected. Trademark protects the film titles, the logo, the brand identity. Like if you watch any movie on YouTube like Uche Bonabo, Uche Montana, you see that like, that logo is always at like the top or beside their movies to show that the movie is their production. So option purchase, secure rights. Like I said, option to purchase agreement, secure rights to underlying works like books and articles. Like I said earlier, The Secret Life of Baba Shegi's Wives the right to adapt same was gotten by Moabudu to release the movie in December. If she hadn't done that, then Lola Shoneyi can institute an action in the court of law for damages. Then music clearance, obtain license for music used. Like I said earlier, also the music Bimbo collected from Uguchi to use in the movie. If she didn't get that and then she used it, Uguchi can sue for copyright as well. Anti-piracy measures use digital protection tools to prevent illegal distribution. These are just like tools to like the Digital Millennium Copyright Act is just to like prevent piracy and just to ensure that nobody feeds on the work on another person without actually working hard to produce it. So music, intellectual property protects creation of the minds as songs, beats, lyrics, just like the movie, it creates every aspect of the movies. Like, and artists are usually entitled to royalties by way of performance, digital streaming platforms, and whatnot. That's how they make their money. And it is very important to like when an artist is signing a contract to go with a lawyer so that all the terms of the contract can be read to his understanding and later won't cause problem. For example, Kiss Daniel, when he was signed to G Worldwide, he he didn't sign a contract because the owner of G Worldwide was his friend, and then he was paying him 30,000 naira per month. Imagine that when all the songs he's singing, every all the royalties was meant to go to him. That was because he didn't actually sign, and then later left it later caused an issue, and then he had to leave. So that's the importance of contracts in the music industry, so that you won't be duped off your hard-earned money, sorry, and work actually. Understanding IP helps artists protect their music, retain ownership, and properly. Exactly. If you do that with a legal practitioner and he explains to your understanding, this will not be an issue, and you'll be able to reap what you sow. Software programs. Intellectual property for software protects computer codes, application, and graphical user interfaces from unauthorized use. So, like Mr. Marx said last week, he said that expression of a software code is like when it is written. While that's copyright. While functionality is when patent comes in. So just the expression of the code in like a written form is like the copyright. So, but when it is functional, that's when you can like institute an action for patent in the court of law. So it's very important to actually know that, so that when any of the if it is the functionality you want to defend or the written form, it is so that you know what to institute in court of law and you won't look like you're unserious. So it's always better to have this understanding of IP so that you won't make a fool of yourself when you want to claim your rights. So this is basically what I've said. Fashion, intellectual property rights protects creativity and innovation in the fashion industry. They help designers safeguard their works, build strong brand identities, and compete fairly in global markets. So trademarks is basically what is prominent here, like the brand identity, like the Vicky James, Maya Tafu, Yomi Casual, Samuel Tigba. These are fashion designers that once you see their brand on social media, you know it's them. So it is very important to have like a brand identity so that when people know or people see your work, they can differentiate your work from others. And when someone tries to steal your work or claim your work, you'll be protected and be able to like get adequate protection and prevent them from using such work. Copyright protects works such as textile prints, sketches, photographs. These are just basic things that can be protected by copyright. IP rights also play an important role in combating counterfeiting, enabling brands to take exactly like I said earlier. Broadcasting refers to the transmission of audio or visual content to the public through radio, television, and online streaming. Like all these radio houses, they have gotten the right to broadcast certain things from the owner of the creation. So they can't just broadcast what they haven't been given the rights to broadcast because the creator can actually sue them and then get damages. Are protected interest by copyright exactly. So like if you breach if you use someone's work unauthorized, then the person can come for you and make you pay for damages. Sorry, I'm trying to speed up the whole presentation. That's why I'm skipping some things. Broadcast organizations have specific rights, including rights to authorize or prohibit rebroadcasting, the right to record and reproduce broadcasting, the right to distribute copies of broadcast, protection against unauthorized streaming or piracy. Exactly. They can prevent any other person that hasn't been given the right to use their work. When IP rights of broadcast are not protected, losses can occur, unauthorized rebroadcast by competition, loss of advertising and licensing revenue. So when the money you are supposed to be making when you are the broadcaster, you are going to lose it because other people have already started using your intellectual property and sidelined the funds or revenue you're supposed to be generating. Comedy. Creative IP in comedy protects comedians' jokes, brand, performances, copyrights, and like, okay, I'll just quickly give an example for this. This is like the case of Sabinus and Pick Milk and Gala, where he trademarked, but they later settled out of court, where he trademarked the statement something huge, but Gala and Picnic used it, and then he sued them for damages for 1 billion and 100 million respectively. They later settled out of court, but that's just to show that he has the right to do that and claim damages if his rights has been, or statement, or his brand has been used without his authority. In digital space, skill makers can face contagion and you protect their work comedian. Importance. Importance of contract and proper contract review of creators. Contracts are very important for creatives such as designers, writers, and artists because they clearly state the terms of their work. Exactly. So it is very important to read the contracts before going into any work so that there won't be issues later. And then it will lead to like a strained relationship between the two people going into the contract. So it is very important to like read the contract and decline whatever you don't like from the onset so that revise the contract if it is possible. And if it's not possible, it's better to walk away than to be caught in a legal um to be caught in like litigation in the court because it can go on and on and on and on and on. The contract explains payments, deadlines. So like basically just talks about everything you're going to do about the production or whatever you're signing the contracts for. It educates you on what to do and what not to do basically. So contracts also protect intellectual property rights under the Nigerian disputes like the one between Blackface and Two-Face. What happened was that Blackface said that it was one that wrote African Queen, that the hit song by Two-Face, and then Two-Face didn't give him any rights. So it was an issue then, and it's still an issue now, and it led to their strained relationship actually till this day. So it is very important to like protect your rights basically. Reviewing a contract before signing helps creatives identify unfair, exactly like I said. So it's always very good to review contracts so that there won't be issues in the long run. There are plethora of cases on this, like in Apple versus Microsoft. Apple claimed Microsoft copied the Macintosh graphical interface, but the courts ruled for Microsoft because Apple has already licensed some features. So Apple had already given the rights to use some features, so they couldn't actually claim rights from Microsoft. So they were not successful in that suit. In Hermes versus Mason Rothschild, Hermes is the known for creating Birkin bags. So the court found Rothschild liable for trademark dilution for selling metal Birkins, showing that trademark protection also applies to digital spaces, not only physical. That if you impede someone's right on digital spaces too, you can also be brought to order. In fact, Louis Vuitton sued Dunia and Brock over similar monogram bags, but the court ruled that copying alone did not prove trademark infringements. Similarly, Adidas sued Tom Brown over striped designs, but the court ruled in favor of Tom Brown due to insufficient evidence of infringement. So, like Louis Vuitton didn't have enough evidence to support their claim, so the court ruled in favor of Tom Brown. Organizations like FIFA actively protect their IP by monitoring and stopping illegal broadcast. Like you can't just stream matches that FIFA has not allowed you to broadcast. So though there are illegal sites which are by they've actually brought down some legal sites that I actually know of, like SGO was an online site for streaming football then that we used to use, but then I think later FIFA found out about it and they brought it down. So SGO is now you can't actually stream on SGO again. Though there are still other ones, but like once FIFA finds them, they're also going to be brought down. So that's basically it. Sorry I had to rush it. I hope that you were able to pick up one or two things from the presentation. Thank you.
All right. Thank you very much, Habib, for running us through your presentation on behalf of your group. Well done to you and to your team for putting it together. It was quite lengthy, but we appreciate the efforts and the time the team corporately put in to get your presentation done. Please, we want to encourage, or I want to encourage every single person in this class that we take our time to really pay attention to the roles that we have been assigned. And if at all, for any reason, you may not necessarily be able to perform in the capacity which you are supposed to in relation to your role, make sure to communicate to your group leaders to ensure that there is a smooth transition of roles and there's a smooth transition of roles between you and your team members so that anybody who can step in and fill in your shoes, they can accurately do that. The reason why I'm bringing this up is because I don't think we're able to get a hold of any of the presenters for the team. Right, so please, in the next class, we would want that to be fully implemented where effective communication is handled amongst the group members so that in the instance where someone will not be available to make presentation, even though they have been assigned to, other members of the group can fully step in that capacity to handle such tasks or to handle that task. So unfortunately, our two mentors had to leave the call. They were kind of busy, so they had to, they were in between schedules, so they had to step off the call for now. But so far so good, considering that we have spent quite a number of amount of time dealing with um, the topic in itself. That is, we talked about IP for creative. Ms. Winner is giving us a background history, not that's a history, just a background into how creatives can take advantage. That's creative, especially in the social media economy of social media space, can take advantage of intellectual property to advance their course, monetize it, and get better deals out of it. And how for us who are students, lawyers, and people who are just general enthusiasts in that space can take advantage of what we have as social media to position ourselves with the intellectual property space still being significantly new, right? Not new per se, but there's still so much to be exploited within the space, right? So we are encouraged to take advantage of that. So yeah, and Mr. Folarin went on to sorry, Mr. Habib, if you can you stop sharing your screen? Thank you. Yes, and Mr. Folarin went on to overall just discuss some of the laws. He pointed out to your presentation and he discussed some of the laws that are captured the copyrights, under the Copyright Act, and how we can still take good advantage of it, giving or citing some example works that have been mastered, including music. He brought up some very, very important examples. So I really hope that we're paying attention to the discussions that are going on. We started from last week with discussing intellectual property, and we talked about the business aspect to it and how to take advantage of intellectual property. Now we are discussing how to take advantage of intellectual property in the creative space. The end to this course or the end to this program is not necessarily just to have you come listen to the mentors give you definitions, right? Definition into the theoretical aspect of things, but through their examples and through them showing you industry standards and how they have navigated some of the issues they've had to deal with in their own spaces. They can bring you into a more professional side to the aspect of things. And I really hope that this is something we are all learning from. And with that, we have come to the end of today's class. Right. The class was pretty short, well, but yeah, let's do well to fill in our attendance, tag our mentors that came to class, share what you have learned on your different social media platforms, and I trust that come next week we would have a full class. Please, I want to reiterate that attendance is compulsory. I noticed that our attendance is dwindling, even though we are significantly quite a lot on the main group, right? So please let's make sure that we are always in sessions and we take advantage of this for the knowledge that you are getting. It relatively costs you little to nothing, right? For the kind of information you are gaining or you have access to, right? So, like I said, let's take advantage of it. Make sure to be in class. Class is just 2 hours once a week. Class is just 2 hours once a week. So we expect that 2 hours for a week should not be something too difficult for you to make out time for, right? Other tasks you are doing it in a team. So we expect that because you people we have multiple people running tasks at the same time, the difficulty and the load should not be on one person, right? So take advantage of what we are offering you in terms of the ability to come meet professionals, right? Take advantage of that by being in class. Take advantage of the connections and the networkings that you are expected to build in between yourselves as mentees and also the mentors, right? Let's do well to ensure that we are sharpening ourselves in the knowledge of intellectual property. We still have 3 weeks to discuss some other aspects and areas of intellectual property, and I'm sure that you'll be learning immensely from them. That's from the mentors that will be getting to mentor you in those sessions. So with that, like I said, we've come to the end of today's session. See you all next week and enjoy the rest of your evening.